got Madam Valerie Waswa, who will be making the presentation. I'm told we've got our colleague Faith Mutune, who's also on this call. And just as a way of background, a few months ago, I think in the month of June, KATA did sign a memorandum of understanding with Data Privacy and Governance Society of Kenya, DPGSK, which is a professional body that brings together this data privacy and governance practitioners with an aim of building the capacity of our members who are travel agents to comply with the new data privacy and governance law, as you know. And because we are a key stakeholder by virtue of the data that we come into contact, our client data, we thought that it would be a good way to be able to support a lot of you, in compliance, but also just to be able to improve your knowledge. Members, you'll be glad to know that we have had very extensive discussions with the DPGSK regarding a series of training that they will be doing, both corporately, but also they will be available, to support you individually if you need you need compliance, but as well as, offering the services, compliance services at a negotiated rate. That we are discussing with DPGSK to see, what rate that will look like. But DPGSK will make available their members who are professionals in this space to be available to support you, in compliance with the law. So today, we are just launching that conversation as a series of webinars, educative webinars, for you to be able to understand the expectations of the law, the provisions of the law, and also how you can make sure that you are not offending the law as somebody that actually processes what is considered private data of our clients. I think those will be our opening remarks. We will be available to be able to support you in as much as we can through this process. But also we are liaising with our colleagues at DPGSK to ensure that they are also available, to support you in whichever way that you will require. That will be it. I want to hand over now to, who's that? Who are we having? Valerie. I can hardly I can hardly see you. I don't know. Maybe we'll just. There's something that the camera is playing with you.
Yes. Yeah. Can you hear me? Unfortunately, I think I really took the theme of this meeting today a bit too seriously. So as we are speaking, I am currently in Diani. So this is my office of the day, hence the lighting, because but I will make sure that I am as audible as possible, and that you can be able to get me, because I'm not even sure if my internet will hold. But if you allow me, I'm going to share my screen and just take it away, because I respect your time and I do not want to take much of your time, if that is okay with you.
That's okay, Valerie. I think once you go into presentation mode, you can even go off video.
Absolutely.
So that I can see you're having a great time with monkeys jumping over your back. So I think once
you ni mambo ya watu wa Kenya Association of Travel Agents. I'm sure one of their members actually organized this. So
Okay.
Allow me to share my screen.
Over to you.
And just start there. So 1 second. So hello everyone. As you heard, my name is Valerie Waswa, and I am a lawyer by profession, and I am very, very passionate about data protection. I'm also a certified data protection officer, but also I'm very passionate about traveling, as you can see here. So I am a member of the Data Protection Governance Society of Kenya, and this is a society that is committed, to just ensuring that it builds the capacity of data protection officers, but also contributes to supporting compliance on all matters data protection in Kenya, hence the MOU that it recently signed with KATA. So without further ado, let me just start sharing my screen, and maybe you can let me know if you can see it. Can you see my screen?
Yes, we can, Valerie.
All right, yes. So as I said, today we are talking about all matters safe data safe clients. As a client myself, and allow me to just start with a short story. Just 2 months ago, I was attending. I was part of a group travel in Malindi. As I said, I really like traveling a lot, as you can see, and the one of the travel agents that was organizing the travel had a camera person on standby, right? So every time we would go from one excursion to another, the camera person would always take us very good photos and videos, and we were like, wow, this is the best package ever, because we thought that these photos are ours. 2 weeks later, after we went back to our respective places. We saw that all our photos were being used for marketing. They were being plastered everywhere on that travel agent's communication pages, and it was just a bit too much. Every time they would invite people to register for travel in Malindi, our photos and videos were being used without any credit to us, without our consent, and without us getting money from it. Influencers make money from, promoting tours and travel, and you all know that, right? And it's a very huge part of the budget for marketing. So with that background, allow me to just, dive right into, the data protection terms, because I do understand maybe I've already started saying some things that you're like, what is this that Valerie is saying? So data protection, as I have just explained, basically I will just start by giving an overview of the description, is that it is the frameworks, right, and the strategies that are put in place to protect personal data. And as you can see, the first terminology there is the personal data. So personal data, maybe I can use an example, is different from data like the number of chairs, the number of vehicles, that is abstract data, but personal data is data that personally identifies someone. So that could be your national identification number. It could be your passport number, your biometrics, your iris, and all that. It could be your email address, your credit card details, and all of that, the medical history, something that if it's pointed out, it can personally identify someone. That is personal data. Then there is something called consent, right? So basically consent is just being or maybe let me just start by saying, let me go to the to this terminology called data subject, right? So data subject is basically the person that owns the data, right? So let's say if I want to come to Diani as I have, right, and you need my email address and my passport biodata to register for me to stay in a hotel, then I am the data subject because you have my data, right? So now if, for example, going back to the example of being taken photos when you're in Malindi, right? If I did not give consent to my photos being used in marketing, then that brings, there's trouble there. So consent is when a data subject agrees to their data being used for that particular purpose. So remember that consent has to be for that particular purpose. So if you say that you're using my email address to register me, to book me in a hotel, and then I later find out that you've signed me up to your email list or your subscription newsletter, and I did not consent to that, then you have extended the purpose for which you used my data. There is something called data protection impact assessment, or what we commonly call DPIS. This is a risk assessment. It's a compliance or an audit process that is done by data protection officers. And basically, this is done before there is high risk data processing. I know that some of you can relate. Sometimes when you're organizing travel itineraries for people, families, right? You find that some of these people, maybe they are high profile people, or they have very sensitive data such as their health information and all that, or maybe you're managing a group travel for an entire school, right? So let's say you're taking an entire school, let's say in grade 6 to the United States. So you're collecting and you're processing data of more than 400 people. So when you're processing data that has high risk, before you start processing that data, you need to conduct something that is called data protection impact assessment. There's also data privacy impact assessment, but I don't want to get very technical because I was asked to just keep it very overview level, right? So if, let's say, you introduce a new online booking system, then you need to conduct a data privacy impact assessment to check for any possible risks of data leaks, right? And because, again, just think about it from the perspective of maybe you are aware about aspects around data privacy, but your employees do not know, and they're the ones that have those data like personal identifiable information, such as your passport, biodata, and all that. So it's something that needs to be done by the entire organization, or the people who are directly and indirectly involved in collecting and processing personal data, just to ensure that if there are any possible privacy risks and safeguards, you put the right measures in place to ensure that you mitigate the possible risks. Then there's something called data breach. I think I've already explained what that is. So data breach is basically when you unlawfully handle and manage personal data. So that could be either that, as I said, you collected this data to do activity A, but then you proceed to do activity B. It could also be that the data has leaked and it is also being used by third parties to which the data subject did not consent to. It could also be that you collected more data than you needed, right? There's something called data anonymization. This is when you remove all identifiers of data so that it can no longer be linked to an individual. So for example, instead of storing on your Google Drive folder or OneDrive folder, Valerie Warsaw passport A123456, you can just say traveler 001. So that way, no one will be able to know that Valerie went to this particular hotel, because, you know, there is a lot of risks when it comes to travel. Imagine if you're organizing solo travel for people and there is a risk for criminal, connections and all of that. You all know the story of that famous athlete who died, and they had to follow up where he last was, and they found out the information in a hotel he had signed up information. When they're registering the number plate details of the car he had when he was checking into that hotel. So such like things. So you want to make sure that once someone has, let's say, left the hotel that you're organizing, or even in your system as a travel agent, let's not talk about third parties like hotels, you anonymize that data such that you only remain with the concept of the data that you need. There's something called privacy by design. So this is making sure that from the beginning, the middle, the in between, and everything around how you manage data is with data privacy in mind. So for example, if you have a website that people use to book for they want to book for family travel or school travel, etc., credit card numbers, there's that part where someone needs to key in their payment details. You want to make sure that those credit card numbers are immediately encrypted the moment they key in that data, and not as an afterthought. I think I've talked as a data protection officer. So for example, the DPGSK is a society that brings together certified data protection officers in Kenya. So a data protection officer is that person who is responsible for ensuring that the organization complies with data protection laws. Sometimes, most times, a data protection officer is a lawyer. Sometimes it could be a more IT person. So I would say the ideal data protection officer is someone who has a little bit of both. They understand the legal landscape, but also they understand the technological aspect of it, because data protection is something that has arisen, especially with the revolution of technology. Then there is the Data Protection Authority in Kenya. The data protection landscape is governed under the Ministry of ICT with an agency called the ODPC. In short and in full, it is the Office of the Data Protection Commissioner. In the European Union, each country has its own data protection authority, such as France. I was asked to talk about that aspect because I understand that sometimes some of your clients are coming in from other countries, right? So there's that authority. There's the data controller. So data controller, let me start by saying data handler. There's data handler. Basically, that is the person who is in charge of handling personal data. And then under a data handler, there are two categories, two broad categories. There is the data controller and there is the data processor. The data processor is the person or organization that processes data on behalf of the data controller. So for example, an airline or a hotel system that receives customer data from your agency. So the airline is the data processor and the travel agency is the data handler, the data controller. So the data controller decides why this data is being collected and how this data is being processed. So let's say if you're also handling the visa processing of a client coming in, or let's say they're traveling from Kenya going to Malaysia, right? So you are the data controller because you're the one who will determine why you need this data, how you're going to process that data, etc. Let's say you want to book flights and all of that. Allow me to go to the next slide because there are so many terminologies under this. So now let's talk about the data protection laws in Kenya, and then we can go to the data protection principles. So in Kenya, the legal landscape on data protection is divided into three broad categories. The first one is the Constitution of Kenya 2010. As you know, just yesterday we're celebrating 15 years of Katiba Day, right? So Article 31 under the Bill of Rights stipulates the right to privacy, and it says that each and every person has a right to privacy, including privacy to their home, privacy to their information, and all of that. So that aspect where they talk about aspects like privacy to their home, privacy to their information, that is where data privacy comes in. And then now from this article, it gave birth to the Data Protection Act, which was enacted in the year 2019. And the Data Protection Act establishes, remember I said the Data Protection Authority. So in case you run into trouble or you need to register as a data controller or a data processor, which I highly encourage you to do so, you're going to be dealing with the ODPC. So this Data Protection Act gave birth to the ODPC. So the Office of the Data Protection Commissioner, and right now the current commissioner is Ms. Immaculate Kasait, right? So this act also sets out the rights of data subjects, as you are going to see. It also sets out obligations of data processors and controllers. So you, as someone who is a data processor and a data controller, there are certain obligations that you're supposed to meet. Failure to which it will lead to a data breach. And when there's a data breach, then you're going to run into trouble in terms of penalties, fines, and your reputation is going to also be at bay. There's also, it stipulates penalties. So in case there's an offense that you commit and the data subject is aggrieved by how you handled their or processed their data, they're going to lodge a complaint to the ODPC, and the ODPC is going to do what? It's going to listen to the matter, look at the evidence at hand. It's like a quasi-judicial body, and then it can issue penalties if you're found liable. The decisions of the ODPC are binding, and you can only appeal to the High Court at very limited circumstances. The Data Protection Act gave birth to the Data Protection Regulations, and currently there are three main data protection regulations. The first one is the Data Protection General Regulations of 2021. So this goes into the meat and the juice and the flesh of the aspects of data protection. There is the Data Protection Complaint Handling and Enforcement Procedures Regulations of 2021. So this basically talks about in case there is a complaint and in case an enforcement needs to be done by the ODPC, how is this going to be handled? How are evidence lodged? How are documentations lodged to support your case or to support against a case? Then there's the Data Protection Registration of Data Controllers and Data Processors Regulations of 2021, which applies to you. And again, as I said, I highly encourage most of you to register as data controllers and data processors. Remember, the ODPC is not here to fight you. I would just encourage that if you want to run a successful business for a travel agency, data is very key at what you do. So you want to make sure you're compliant from the get-go, right? And members of the Data Governance Society of Kenya are willing and to help you through that journey and to work with you that journey. I would like us also to talk about the GDPR because, as I said, it's either you're helping Kenyan citizens to travel to other parts of the world, right? So travel is a very cross-border kind of, kind of business. So you're not only supposed to comply with data protection laws in Kenya, and in this case, I'm using the GDPR, but it could be that maybe your client is even traveling to China. So the data protection laws of that country are supposed to apply, right? So it doesn't matter that the company is registered here in Kenya, let's say Kachumbari Travel and Tours is registered in Kenya, as long as you're processing data and the data subject is, let's say, a German citizen, then by that nature, you're supposed to handle that data with regards to the laws of that country or continent or region. So in this case, there is the GDPR, that is the regulatory board framework that governs data protection in the European Union. So all countries in the Europe continent that have ratified and signed the GDPR, and you're handling data for someone who is going to or coming to Kenya, then you're going to be bound by the GDPR. So these are some of the main provisions under the GDPR. There is the territorial nature of it. So that means that, as I say, I think I've already explained that. Then there's also, it has also some other aspects of the principles of data protection, and one of them is lawful basis for processing. So, for example, if you are collecting data such as passport details, or even financial information such as credit card details, it should be used for a lawful purpose. You cannot use it to do something which is illegal. Otherwise, then you're moved from processing that data lawfully to illegally, which attracts new fines. Some of them are data privacy related offenses, and some of them can even proceed to being criminal sanctions. It also talks about the right of data subjects, such as, and this is very similar. And by the way, the Data Protection Act in Kenya has really borrowed heavily from the GDPR, because that is the first very comprehensive framework under data protection, I say, in the world. And so Kenya really borrowed a lot from this act. So what you're seeing here is what is in the Data Protection Act of Kenya. Talks about right to access. So a data subject can request what data you hold on them, right? So for example, if I ask you to unsubscribe me from your email list, you should do that with immediate effect. If I tell you to delete my passport scanned document from your drive, you're supposed to do that. Sorry. And then there's a right to data portability. So that is aspects of transferring travel history to another agent. I'm so sorry. I think, oh my goodness. Let me just rush through this then. Why does data protection matter in the travel industry? So one, as I said, you're handling very sensitive travel, personal information. Sometimes this includes health data. Sometimes this includes financial information. Sometimes this includes passport details and all of that. Then there's the cross-border nature of business. So you're not only because of the business you're handling, you're not only complying with Kenyan data protection laws, but with every other country whose data you're handling. So you're at more risk to be in trouble if you're not compliant. Another thing, privacy equals trust, right? So when you handle clients' data with respect, with confidentiality, what does that mean? That means that they're able to trust you. They're able to trust you to be their partner every time they're considering to organize travel. Another thing is hefty fines and penalties. Data protection related fines and penalties are very, very hefty in millions of Kenyan shillings. That is just for the Kenyan Data Protection Act. And the amount even goes up in euros and US dollars when we go to other jurisdictions. Right of data subjects, I think I talked about, just as they are in the GDPR, is the same as in the Kenyan Data Protection Act. They have a right to be informed, they have a right to access, rectification. That is, they can ask that you correct their data. They have a right to see their data. They have a right to object to processing of all or part of their personal data. So these are some of the penalties under Data Protection Act. So one of them is that, as I said, like if you fail to comply with the provisions, you can get a fine of up to 5 million Kenyan shillings, or if you're making even more money, the amount goes high, whichever is lower, so or 1% of your annual turnover. The offenses include failure to register as a data controller or processor, unlawful disclosure of personal data, obstruction of the data commission, let's say when they want to conduct investigation, suspension of processing activities, reputational damage. And you know that, and even the Bible says, for those who are Bible believing, that reputation is more worth than gold and silver and everything. So you know and understand that in a business such as travel, where it's largely by word of referral, you want to make sure that people can trust you, right? And they can speak well about your business. So you want to make sure that you have a good reputation with your clients by ensuring that you respect their personal data. Penalties under the GDPR include, so in the GDPR is a bit different. There is tier 1 fines, there is tier 2 fines. Tier 1 fines, this is up to 10 million euros. Can you just convert that to Kenyan shillings? I don't think it's worth it. You'd rather just be compliant. Or 2% of your global annual turnover, global. So meaning if you combine all your mother and children and companies together, that global annual turnover, whichever is higher. So unlike Kenya, which is whichever is lower for the GDPR, whichever is higher, that is the fine that you pay. For less serious breaches, e.g. record keeping or not notifying the authority of a breach, that is where this tier 1 falls under. Tier 2 fines is up to Tier 2 fines is up to 20 million euros or 4% of global annual turnover, whichever is higher for serious breaches. Hello, can you hear me? I think I am done with my presentation. I'm so sorry for the background noise, which is very annoying, but thank you for staying with me up to this end. Asanteni sana.
Asante. I think members, if you have any question, you can raise now as we move to the next presentation by Howie.
Yes, hello. You can hear me all?
Yes, you're clear.
Okay, I'll just start presenting what I have. Let me just. I hope you can see my screen. Hello?
Yes.
Oh, okay, good. Yeah. Okay, so yeah, I'll just jump right into it. Yeah, so yeah, I'm breaking down what it is to be a data controller and a data processor and why it matters and what obligations come with each role in your daily operations. I think I'd forgotten to introduce myself very quickly. I'm a lawyer by training. I am also trained in cybersecurity and data protection. I have been a professional member of the data protection of the DPGSK, and yeah, I've been a member for the past 2 years. So yeah, just going into my presentation. So I believe that we've already been told. Right. Okay, yeah. So I believe that we've already been told who a data controller and a data processor is. The definitions are found under Section 2 of the Data Protection Act. Basically, a controller is the person who calls the shots, decides how the personal data is to be processed. For instance, let's say if you decide what client's details are needed for flight booking, you're a controller. And a processor, on the other hand, is a person who follows the instructions of the controller. Let's say when you input data into an airline system on behalf of a client, basically you're a processor. So why does this matter? It's important because the distinction helps. What can I say? It affects accountability. A controller bears a bigger burden or a legal burden, whereas a processor has clear duties. So in the travel industry, let's say yeah, you're booking a flight or processing a payment or handling sensitive visa data. If something goes wrong, the law will ask, were you a controller or processor? So it's important. That's why it's important. These obligations are placed by law, and yeah, there's a very serious legal implication. Yeah. So yeah, core obligations of a controller. So as a controller, basically, you must always have a lawful basis for processing the data. So it's often through consent, or basically, even with when consent is not obtained, it can also be on the basis of you're fulfilling a contract with the client. So you have no choice, but in order to fulfill that contract, a valid contract that you have with the client, you need to collect that data. So that's again also a valid basis. And also, you have an obligation to collect only what you need and to keep it accurate. And you must also be transparent. The client must know what happens through the data. They should receive a notice. And also, if you're sharing it with a third party, you must also account for that. You must also remain accountable for that. Yeah, so now with regard to processors. Now, as a processor, basically you're bound to follow the controller's instructions. You cannot go beyond them. Let's say you've been given data for specific reason. You cannot now say, oh, I have this other purpose I want to use the data for. And also, you're required to implement proper security measures. And if there's a breach, you must notify the controller immediately. And you must keep all records of your processing activities and to demonstrate that you have complied with the regulations. Now, third parties, yeah, basically a third party is also an important, what can I say, is someone who is also regarded under law, under the Kenya DPA, and yeah, it's a person other than the data subject or the controller or the processor, and or person acting under a direct authority under those people. And so sometimes it can include a government agency, or yeah. various organizations like that. So when you're working with partners like hotels or airlines or payment processors, contracts are essential. You must spell out what role everyone is playing, what responsibilities, and how to handle the breaches. Ultimately, clients will hold you as a travel agent responsible. So when data moves to a third party, your reputation and your legal responsibility is what will remain on the line. So what can you take away from everything I've just said? Clarity is important. Clarity on your role helps you understand your responsibilities. Compliance helps you build trust with your clients, and protecting data is not just about legal requirements. It also protects your brand and your business reputation. Now, moving on to the next module, data subjects' rights. Basically, your clients' rights. These are central to data protection laws, and they help ensure that your clients feel respected, and they ensure that they keep on work and so that they can keep working with you. So what it boils down to is that when a client gives you sensitive data, their passport, their travel history, their payment details, you are to respect their rights, and and this will in turn help you build trust, and it'll help you strengthen your relationship with them. Ignoring these rights not only risks your not only do you risk fines, but you also risk your reputation. So I believe my colleague Valerie had already covered the rights to be all the rights of a data subject, but just to go into a bit more detail. So the right to be informed. This you can find this under Section 26A of the DPA. Section 26 basically lists all the rights of a data subject. So under Section 26 of the DPA, a subject has the right to be informed of how their data is going to be used. So basically, you must explain clearly. For example, when you're booking, you must let them know that you're collecting their passport detail and that it might be shared with airlines or embassies and things like that. And also, you find also consent is also detailed. Of course, there's an interpretation of what consent is under Section 2, and also under Section 32 of the Data Protection Act. It goes into detail now about consent, when it is obtained and when it's withdrawn, and what you're supposed to do. The next right I'm talking about is right of access, again under Section 26 of the DPA. So a client has the right to ask to see what data you're holding of theirs. Maybe their entire booking history or copies of their visa records. You must be ready to provide that in a clear, accessible format. Right to rectification. You see under Section 26D and E of the DPA, as a data subject has the right to seek correction or deletion of false data or misleading data. So basically, if let's say you have misspelled a client's name on a booking, or you have the wrong passport number, they can demand it to be corrected. And of course, you can imagine in a situation where someone is traveling, it's very important that details must be accurate, because missing a detail could mean you miss a flight, or it could mean having visa issues when you arrive. So for a travel agency, it's very important that details must be correct. Then the next right is right to erasure and the right to be forgotten. Under Section 30, basically, I think, Section 30 details what is lawful processing of data. And Section 32, I explained earlier, it explains the conditions of consent. And yeah, so basically, a data subject can withdraw their consent to data processing at any time, and the processor or controller must delete or destroy the data immediately upon withdrawal unless there's a lawful basis. Unless, let's say, to comply with a law or to fulfill, of course, I mentioned earlier, to fulfill a contract. Yeah, other than that, a client has a right to have their data deleted, especially like, let's say, if it's no longer necessary. For instance, like old travel records, there's no reason for a travel agency to keep, let's say, someone's travel records from 1 year or 2 years ago. By then, under the law, the retention period is over. Yeah, but yeah, of course, like let's say for tax purposes and things like that, of course, you may be required to keep those records. But under any other circumstances, a client has a right to be forgotten. And yeah, the next right is the right to object to processing. So under Section 26C of the DPA, a data subject has a right to object to processing of all or parts of their data. I've already spoken about this earlier. Let's say, and of course, object to certain types of processing. Like let's say, for instance, as a travel agency, you'll even after the client has left you, you might want to send them marketing emails, or you might need to use their data for some sort of profiling, of course, with their consent. But the data subject has the right to opt out, and you must, even when you're asking for, when you're requesting their data for these purposes, for commercial purposes and all that, you must make it very clear that they can opt out at any time, and you must provide the means of opting out in the documentation that you provide them with. And yeah, the last right I'm going to talk about is the right to data portability. This is detailed in Section 38 of the DPA. So yeah, so basically, this means that the client can ask for their data to be in a format that allows them, that makes it easy for them to move elsewhere. For example, they might need their booking history to be transferred to another travel agency. So yeah, basically, these laws, they protect it's about giving your client the control and flexibility of, and the freedom of, with regard to their data, which is very important, as we have said. So yeah, just to bring all this together, so all these rights, they work together to give a client control over their data. You should provide simple ways for the client to make their requests, like an email address or an online form. And importantly, you must respond within a reasonable time as required by law. And yeah, the final takeaway I can give is basically that your client is the owner of their data, and you're only their custodian. By being transparent and respectful to their rights, not only do you build loyalty and strengthen your brand, but it also satisfies your client. Because yeah, safe data does really mean a satisfied client. I believe, I don't know if yeah, that concludes my portion of what I wanted to say. Yeah.
All right. There was some questions that members had asked prior to this webinar, and I would like to present them to the DPGSK team. They'd be able to help us respond to them. So as one of them is matters compliance. I think we've covered that, but just for clarity, maybe you can respond to the compliance requirements for a data.
Perhaps I can proceed with the next presentation. Then we have an entire Q&A session that covers all those questions.
That would be okay.
Yeah. So my name is Faith Mutune. I'm also an advocate and a member of DPGSK. As you've heard from my colleagues, we're not just advocates in this society. We have quite a diverse community. We have people who are also in the tech space. We have people in academia, civil society, private DPOs, public DPOs. We also support some 2 student bodies. So once you appoint your DPO, you may have them also join our society as a member. They will benefit a lot from the CPDs that we have regularly concerning data protection and privacy, just to capacity build within our own membership, and also discuss areas that may be challenging for different parties. So I'll be tackling accountability in the travel management, travel data management. So on this, I do recognize that there are various parties who have a responsibility within this space, so that for you to effect your client's instructions, you may need to deal with the airlines. I recently discovered that people called consolidators. I did not know about that. You will deal with hotel booking platforms, maybe visa service companies, or maybe you are a hotel booking platform, insurance providers, ground transport companies, and payment gateways. So it is very important to also know who is responsible for safeguarding client information at these stages. Harvey has talked about who a data controller is and who a data processor is. Basically, one is the one who is determining the purpose of the processing, and the other party is the one who acts as per the instructions of the processor. But in some cases, you will find that there are 2 parties who are working together, and they are both controllers, or there's a processor who is also working with a sub-processor. So it's very important for you to assess your own organization's practices and determine where you fall, and also assess who you work with or who you partner with, and determine what their role is. And this is very important because you need to be able to determine what kind of an agreement you will need to enter into with them if you need one. Yeah. So for example, as a simple case study is agent, where there's a travel agent, and in this case, ideally, client to agent, the agent here will be the controller. Agent to airline, you see with an airline, it also determines its own lawful purposes for processing that particular data. So between you and that particular airline, it will be controller to controller. Both are responsible for compliance, but separately. Scenario 2 would be maybe where there's a package holiday with a hotel plus transfer. So between client and agent, it will be, the agent will be a controller. Between agent, again, booking platform, because it has its own, especially the large booking platforms, but again, it depends on what you want them to be doing for purposes of processing the data of your clients. It could be a controller, or it could also be a controller processor. It still depends on who you're working with and what it is that you want them to be doing for you. But then you have a situation where you maybe you could be also organizing for the transportation. So in this particular scenario, the person who is offering the transport is only acting and as per your instructions. because you need to get your client from point A to point B, and they're just offering a service. The service that they're offering is only for transportation. So in this particular case, they're not really determining the purposes for which you're collecting data, because you're collecting that data, and part of your responsibility is to provide that transport. They are facilitating that process. So in this case, they could be only a processor, so that you restrict the manner in which you restrict the amount of data you share with them, the nature of the data, and also the basically instructions on what they can do with that data. So forth and so forth. So in terms of legal and practical responsibilities, that ability to determine that what your roles are is very important, because it has a bearing. So for you to be able to do this, you need to conduct due diligence, sometimes even with the people who you're offering services. The whole purpose is to ensure that they're also compliant. Because if you're a controller and you're dealing with a processor who is non-compliant, you risk being found also in breach, because the primary responsibility of compliance when you're dealing with controller to processor remains with the controller. So if you have a processor who is not compliant, who's not aware of protection of people's private data, personal data, then there is a risk of breach, there is a risk of violation of the law, and that breach will come back to you. Again, you need to have clear contractual terms between yourself and the entities that you're dealing with. So in some entities, you will realize that you need to enter into data processing agreements. Now, under these data processing agreements, there are various, so there could be a controller to process agreements. There could be a controller to controller agreement. There could be a controller to a processor to sub-processor agreement. There could also be joint control agreements. So again, being able to determine the scope under which you're operating with the other parties is very important. You also need to have transparency with your clients, so that you inform them that where you're collecting that data and with whom you shall be sharing that data. So for a whole itinerary, when you're doing your privacy notices, the client should be able to know, once you collect my data, who are you likely to share that data with? What scope of data are you likely to be sharing with them? And for what purpose are you sharing that data with them? You should be able to also outline the security measures that you have put in place to ensure that when you share that data with the other third parties, your client's data is secure. And how do you do that? You do that by ensuring that they are also compliant, because if they're not, again, it reflects back to you. Again, imposing security and confidential obligations. And then between you and the other parties that you are working with security and confidentiality obligations, it means that if you are going to share data with any party for any purpose, they should also adopt similar measures of security as you're adopting, or even better. And you should also have an obligation under that agreement that requires them to maintain confidentiality of your client's personal information. Again, what happens if there is a breach held by a party with whom you had shared that data? There must be clear terms as to how a breach response will be coordinated. How will they respond back to you, and how will you deal with the data breaches? Because you must coordinate, you must jointly, coordinate to ensure that the data breach is contained, and any measures that need to be taken to ensure that that doesn't happen again are taken all round. You need to also have monitoring and audit rights. So whenever you're acting with any third party, and you are the primary, especially where you're controller and processor, you must ensure that you have audit rights, meaning that you can audit their data protection compliance processes, or basically their practices, to determine whether their practices are sufficient to afford your clients the kind of security that your clients require for their personal data. So the audit requirement is actually, I think in GDPR, is actually imposed by the law itself. And even here, it is highly recommended that any agreement that you have you must maintain an audit right. Again, I don't want to repeat what happens when you do not adhere to these terms. We have been taken through the risks, financial, reputational, and operational risks. So as a best practice, always identify whether each partner you're dealing with is a controller or processor, and classify, categorize them. Use written agreements to define the responsibilities of each party. And because of the technical aspects or the things that really must go into this agreement, it is highly advisable that you use a professional who will guide you and to the kind of terms that are going to be contained in this agreement. In fact, by the way, when you talk about instructions, when you say that the processor acts under the instructions of the controller, you must be able to demonstrate those instructions. So where are those instructions contained? Some people put the instructions of an addendum to the agreement as part of the agreement, so that it is very clear from the beginning what instructions you are bound by. So it's very important to have that. Share only what the necessary data, so that even from the point of collection, collect only the data that you require to be able to fulfill your obligations and the kind of service that the client is seeking. And when you share the data, you only share the data that is required for that person to perform only that part of their obligation. So if for example, somebody is performing just a part of transportation, what do they need? What do they need for them to be able to collect a client from the airport and take that client to the hotel? So don't give them unnecessary personal information, which now also enhances the risk of breach. Yeah, inform clients clearly about data sharing. We've spoken about that. And then also put in place breach notification protocols. Periodically, again, we've talked about the audit, review your partner's compliance, and keep documentation to demonstrate accountability. Currently, I think we have over 8,000 complaints that have been filed with the ODPC, and they're going to get even much more as people get more enlightened about their rights. So one of the things that has worked for some people when they're defending themselves when these complaints arise is their ability to show documentation of what they have done, the steps that they took to educate their employees. They have the necessary notices, they have the necessary agreements in place, consent has been obtained, and there is a record of that consent. So it is very important to have all this information recorded properly, because when it comes to a complaint, you will be required to demonstrate all these things. And if you can't demonstrate, you are likely to land a fine. So it's important to give very accurate records. Appointment of a DPO and what their role is. Now, when you're dealing with your roles as under the Act, there are those people who must register as data controllers or processors. Yeah. So the law provides a threshold for who is to register as a data controller or a processor. That is any entity who has that has over 10 employees and whose annual turnover is over 5 million. Yes, but then there are those ones, those entities where, irrespective of your annual turnover, even if it is 1 million, and irrespective of your number of employees, even if it is 1 or 2, you are still required to register as either a data processor or controller or both. Those entities are defined under the law. So the people who are in the hospitality industry are part of those who must register as a mandatory compliance obligation. So when you're registering, part of the requirement that you will be asked to fill in your registration process is to identify who your DPO is and give details of your DPO. The DPOs are data protection officers. You can appoint a DPO or you can designate a DPO from staff already existing within your employment. Yeah. In appointing these DPOs, you could have even an employee being a DPO or an external DPO. So for example, like there are many entities currently or people who are acting as external DPOs. So they're not in your day-to-day or month-to-month payroll, but you have an arrangement with them where whenever you need a DPO or you need anything done, they're the ones who are going to take over. Some people who have these arrangements, especially if the company is not so large, you can opt for this external DPO option. For example, I have acted in quite a number of entities as an external DPO. Some people will ask you to help them with the initial part of the compliance because it's very heavy. And then work with a person who is going to be an employee who will take over once you have assisted them with the initial part of compliance. So it all depends on the nature of relationship that you want to have, or the steps that you want to take, and also the resources that you have at the moment. So the DPO under the law must have knowledge on data protection laws and practices. They must be able to demonstrate that they have that knowledge. So once you've designated a DPO, you either appoint a DPO who is already having the knowledge, or once you designate, ensure that this person gets some proper training and is able to, to demonstrate that he has that knowledge and capacity, because there are roles which are prescribed for a DPO under the law. So our law is currently narrow on the scope of the role of a DPO, but we are currently in the process of amending the Data Protection Act, and there was a high recommendation that the scope of the DPO's responsibilities be expanded. So these roles which are put in our act do not limit you. You always, I'd advise that you always aim for international standards of compliance. So under our act, the DPO's role is to advise the organization on data protection obligations, to monitor compliance with the Data Protection Act, and to serve as a contact point with the Office of the Data Protection Commissioner, that's ODPC, and to train staff and raise awareness on data protection. So you see, for them to be able to monitor compliance, they must have that knowledge, or to train staff, they must have that knowledge, yeah? So evaluate what your current needs are, whether you need somebody who's internal or external, and see then how you can appoint, because it is a requirement that you must register. What is important again is that a DPO must act independently, without conflict of interest, and report to the highest management level. This is because of the fact that the DPO, sometimes in exercising their roles, they will be auditing the practices, data handling practices of various offices within your organization. And so they must have the independence to be able to do what they require to do without, being fettered because of the fact that, they have their supervisor who is also assessing them, is also the person who is responsible for a certain aspect of compliance, and they haven't complied. So ensure that that conflict is not there, so that they are able to work without fear or favor, for the benefit of the organization. Remember, the whole purpose of the DPO is to work for the benefit of the organization. So if they work in a way that is independent, it helps the organization more than if they are working in a place of, if I do this, my supervisor is going to give me a bad report on this particular end, is going to be a challenge. And ensure that for purposes of reporting, the DPO reports to the highest management level. So again, that still promotes their independence. Again, if you change the DPO, the appointment should be communicated to ODPC. In essence, that the ODPC must always have the records of your current DPO. Remember, this is the contact point between your organization and the ODPC. Again, when you have a DPO, when you have your policies, when you have your notices on your website, you need to indicate who the DPO is and how this DPO can be reached, because of the exercise of the rights that Harry has just spoken about. We'll tackle that in a moment. So then, what are the practical compliance steps that you can take? You must start with data mapping. Mapping is you being able to identify the kind of data that you hold, and being able to classify the data. Are you holding personal data or sensitive personal data? Are you collecting sensitive personal data? Because there are those two categories of personal data. Is it just personal data or sensitive personal data? And once you are able to identify this information, you need to be able to have a record, basically, on how you process this particular data. So now, that is what we're calling a record of processing activities. It is a requirement under the law that you must keep a record of processing activities. And you see, this is basically like the foundation of every other step that you will take in this compliance journey, because you cannot be able to secure or protect the data against a risk if you don't know in the first place what kind of data you're holding. So go to your emails, go to your registration forms, go to any place where you collect data, website, any place, and map out all the kind of data that you collect, and then classify that data. Once you classify that data, create your register. And once you have, with the register, you determine how are you collecting it, include that in the register. Where are you sharing that data? With whom are you sharing that data? For what purpose are you sharing this data? Where are you storing this data? It should be in your record. And for how long are you going to be retaining this data? And if you need assistance, it is best to get assistance to actually come up with a rover, because that is the basis of a lot of the actions that you need to take. So for example, the next step is now to build a risk register. For you to be able to build a proper risk register, you must already have known the kind of data you're holding, why you're storing it. So if I'm storing it in the cloud, what is the risk that is associated with data which is stored in the cloud? If I'm sharing it with the insurance company, what is the risk that is associated with me sharing that data with that insurance company? So when you go with these steps, it becomes easier to take the next step. Valerie has talked about conducting a DPIA. I will not really go into that so much, but basically DPIAs happen. This is a data protection impact assessment. It happens when you have high risk processing. For example, when you, and the processing activities that you will undertake are likely to impact the rights of other individuals or even your data subjects. So for example, when you're coming up with a new technology of collecting information, and there are so many vulnerabilities, and you will be dealing with thousands and thousands of personal data moving from one place to another, that already, before you implement that new technology, you need to assess whether you will need to have a DPIA. And this is very important because when that happens and you're dealing with high risk processing, if you don't conduct a DPIA, then you are likely to find yourself in trouble with ODPC, because the DPIA is, once you conduct your DPIA, you must have a report within and submit that report to the ODPC within 60 days. So the ODPC can see that when you're implementing these high-risk processing activities, you have already put in sufficient measures to protect that personal information. And it is mandatory that that report must be shared with the ODPC and within a particular timeline. So before implementing new things, you need to consult with your DPO. They should be able to inform you whether you need to have a DPO or not, how to do it, and how to have your report done accurately. Review your third-party agreements, like we said, all of the parties agreements that you have with different parties, especially the ones who are going to be handling other people's data. You need to review them and see where the weaknesses are, and amend them to include data protection provisions. Another point that is very important is your agreements with the employee, and that will come out clearly in the next part when I talk about one of the cases that we have, so that your employee is also to sign an agreement that says that they have also an obligation to maintain confidentiality and also to protect the personal information of employees. But you cannot impose this obligation on your employee if you don't have policies, and if you don't have the right notices, and if you have not trained that employee. So I train you. I have told you what my policies are, and I have put in your contract that now you are an obligation to observe these policies and to observe the law, which you already know. And so if there is a violation of that, any policies by the employee, then you can use that as a defense and say, hey, I had already communicated this, there was already clear policies, so this employee went outside the scope of their responsibility and occasioned this breach. You need to develop the notices and policies and procedures that are necessary for this purpose. One of the biggest duties of any data controller or processor is the duty to notify, which is what we've talked about. You must notify your data subjects, what you're collecting, where you're storing it, how you're securing it, all these things. This is contained in a notice, in a privacy notice. A privacy notice is different from a privacy policy. You could have your notice in your policy for so long as you make it accessible to the people you intend to communicate to, the data subjects. And the notices could be outward and also inward looking, meaning that your notice is with information that you're collecting from third parties, data subjects, clients, and also information you're collecting from employees, because employees are also data subjects. And they should also get similar notice on how you're collecting, what you're collecting, how you're storing, when are you going to dispose of it off, and all those things, yeah? And clear procedures. So for example, you will find some policies which some people, I say this because it has been a problem in some scenarios. Some people will just download a policy somewhere and, sort of like take that as their policy, the organization's policy. But when you have a policy which does not say what the procedures are, that policy is almost incomplete. So you're saying, okay, we are going to ensure that we collect consent. Very good. You have captured that aspect of compliance. But then how are these employees to implement this policy of consent management? It must be very clear who is responsible. Once we have a data subject access request, if the request is coming through this email, who is handling it from the first point up to the last point of complying with that request? The procedures must be clear, because if these procedures are not clear, then you cannot assign blame to anybody. And when you have clear procedures, you also assign roles. It becomes very easy then to trace back to who was responsible for ABCD and why didn't they do this part that they're supposed to be doing. Again, we've talked about clear consent and data subject rights management framework, which is very important. Having spoke about data subject rights, I'll add one or two things that when you're dealing with data subject rights, there are timelines which are provided under the law under which you must comply with these rights. So for example, if a client is asking to access personal information that you have on their behalf, you have to comply within 7 days. If they're asking for rectification, you have to comply within 7 days. If it is erasure, 14 days. If it's an objection to processing, it's 14 days. If it is data portability, it's 30 days. So if you know these timelines, then you are able to avoid a situation where a data subject feels like you are not complying with their rights and they go and complain to the ODPC, which will land you in trouble. So again, all these things should be captured in your policy, both the rights and the timelines and how to do it, so that now it is very clear to every employee handling it what then they're required to do. Appoint a DPO, like we said, and then staff training and awareness is very important. Most of these breaches that occur, it is always because of the lack of awareness by the staff. So training staff is okay. In fact, when you go to register as a data processor or controller, you will not be able to actually complete and get your certificate of compliance if you're not able to demonstrate there is an aspect of staff training and awareness within, your current practices. Ongoing monitoring and auditing is also very important, like we spoke about. Have a clear plan on how you're going to deal with incidences of breach, because the law already provides how you're supposed to be dealing with breaches. You must report a breach. So you cannot be able to report a breach if your staff do not even know how to identify that there is a breach in the first place. Yeah. So when they are able to identify, when you have a clear policy on breach management and incident and breach management, then you're able to know how to identify a breach, and your staff is able to know how to identify a breach, how to communicate and how to contain a breach, how you will report to the ODPC and all relevant organizations, of course, because maybe you want investigations to be done, or you may need to involve DCI if that is the case. Also, you need to communicate with the data subject. So you need to know in what instances, when that breach occurs, do I need to communicate with the data subjects, and when do I not need to communicate with the data subjects? It is always important as a best practice to communicate this with the data subjects so that they don't panic. In fact, I think I attended another meeting where, in fact, one of the people who were presenting was saying their data actually had been, there was a data breach by an airline that they were traveling with. And the mere fact that this entity communicated that breach to them and communicated in time, they felt so, they didn't panic. They didn't feel like, oh, now, my data is going to be all over the place. And when you're communicating this breach, you inform them on what to do. If there is something that requires, for example, if it's card information, when you give them that advanced notice and communication, they're able to take steps, even maybe with their bank at block, maybe certain cards. But if you don't communicate, then you expose yourself to even a bigger problem, because imagine if you have 100 people complaining and all of them are demanding damages. So when you look at even the financial implications, don't look at the 5 million or 1% of the turnover, because that is just one part of it. If you have people who are complaining and the ODPC awards them damages, and you have 100 people, it's going to be crazy for you. So that is very important. And we've talked about clear records. Have clear records, and then you need to register, like we said, as a data controller or processor, or both, depending on what activities you're doing. So I'll quickly just run through 3 important cases. There is one relating to Perpetua, Njiko, and Casavera Lounge. It's one of the highly publicized cases that came out when ODPC was enforcing compliance. And in this particular case, this complainant's image was posted on social media without their consent. So an employee of this organization took a photo of the complainant and posted it online for promotional purposes. And in their defense, they were saying that consent was given when the complainant posed for the photograph. They notified the customer via a privacy notice displayed at the lounge. So there are 2 key issues that I want to highlight here. That you cannot presume consent. Consent must be very clear. It must be very unambiguous. It must be freely given, and must be very clear, and it must be recorded, the consent. So now you cannot say the mere fact that I have posed for a photograph when you're taking photographs means that you can put me on your website and your pages and say, as you're promoting your business and your activities, basically. Again, another thing that was an issue in this particular event is that there was a privacy notice, but it was like in a cupboard displayed somewhere behind the entrance as people were entering. Yeah. So we've talked about the duty to notify, which means you're notifying the client of all those aspects of compliance and how you're processing the information. Basically, it's processing information. So basically, if you have put your notice in a place where a data subject cannot be able to see it, if they're walking into your place or if they're going to your website, then you've not complied with the duty to notify. So not only don't you need to have the notice, you must also deal with the notice in a manner that enables the data subject to see or to have information what is contained in your notice. Well, in this particular case, when the complainant complained, they removed the image promptly, but that again, that the damage had already been done. So basically, the ODPC's findings were that posing for a photo is not a proof of consent, and the privacy notice at the launch was insufficient for proper notification. It did not contain all the elements that must be contained in a privacy notice under the law, and also it was not visible to this particular complainant. And this particular case, they were fined 1.85 million. And I think they have not succeeded. I think they ended up paying, even if they were to appeal, they would not succeed because there was a clear demonstration of violation. Another case that I want to highlight is the case of Pauline Mhanda versus Safaricom. And the complainant here is that an M-Pesa data was accessed and shared without consent of this particular data subject, who is Pauline Mhanda. And here the employee received and disclosed this particular complainant's M-Pesa statements, of course, without their consent and without even the knowledge of the employer. Now, this is where it gets interesting, because Safaricom's defense was that they had policies and already safeguards in place. And the employee acted outside of these official duties. And so there was no vicarious liability for personal misconduct. Remember what we talked about earlier, that when you have these measures in place and you train employees and you put these obligations in the contract, it becomes easier for you to escape liability. This is what happened with Safaricom, because Safaricom was able to demonstrate very clearly that they have trained the employees, they have the policies in place, they have safeguards in place. So if this employee did this, they acted outside the scope of their job description. And so the ODPC found that the Safaricom is actually not liable for this. Yeah. And so ODPC recommended actually criminal personal prosecution of the employee, as opposed to filing Safaricom, because of the fact of these factors that already existed, that the measures that they already put in place. So it's very important that you have these things well outlined in your documentation as well. The last one is a case of a tour company from Hungary, which was handling personal information and the customer's data, which is the name, contact information, passport number, ID, and ID copies, were exposed online, basically on their website. And how they came to know about these issues, an ethical hacker is the one who notified them. They were not even aware that this information is out there for anyone to pick it up. And so this exposure actually lasted for a couple of months, from November 2013 to February, is about 4 or 5 months, and it affected 781 individuals. Yeah. So when they were, of course, when they were cited for this complaint, for this issue of infringement, they had no defense. Yeah. So it was found that they violated the law, and they were fined 55,400 euros in fines. So you can see the implication can be very serious if you do not adopt proper mechanism for protecting this personal data. I think that is the end of my presentation. We are all ready for the Q&A part.
Hi, Faith. Is everyone from your team done presenting?
Yes. We are now done with the presentation, so we can take the Q&A.
Before the Q&A, there were questions members had sent earlier. I think we can look at those even as we.
Yeah, if I can maybe jump in, right before Faith's presentation, I had seen one of the participant had asked a question that was not very clear. Basically, they asked they were asking about the compliance requirements of a data collector. I had seen, and
Yes.
maybe what I can say is that the term data collector is not defined in the DPA. I think what the person had meant is either a data controller or a data processor. So that being said, yeah, a person who collects data under the Act, at minimum, their compliance requirements include the lawful basis, which are already covered. You are either you've been given a consent, or you are under a contract, or some sort of legal duty requires you to collect that data. Transparency, you must tell them why you're collecting that data and how it'll be used. Data minimization, only collect what is necessary for the purpose. Security, you must put in safeguards in place to protect the data from loss and misuse or unauthorized access. And of course, you must respect the data subject's rights, access, correction, or deletion. So yeah, those are the law, the compliance requirements basically of a data collector.
Okay, there's also another question of how travel agents can comply with data protection, as well as a regulatory requirement for IATA to mandatory inclusion of the traveler's details when booking products.
I can take that. So basically, ideally, it's just to look at the entire compliance process as required under the Act. Now, when it comes to this information, especially you're talking about the requirement of IATA to mandatory inclusion of travelers' details, then Valerie talked about principles of data collection, and one of them is a lawful processing of personal data. So, for example, for so long as you have a lawful basis for processing that personal data, you can collect that data. So what you need to be able to assess is if there is a lawful basis. So for example, for this is, I don't know what you call IATA. Is it a regulatory body So if it is a requirement of compliance under the policies of that regulatory body, then you have a lawful basis for collecting that information and giving that information.
Okay, thank you. Also, the costs that are attached to maybe compliance.
That depends entirely with the size and the needs of the organization. As you see, there it could be anything from 2 employees to 100. It could be even the nature of the activities. You could even be 5 employees or 5, but you're dealing with also large scale data. For example, if you're a processor, if you're a payment card processor, even if you're not many, the scope of the data you collect is still a lot. So that would depend also on that and the kind of technologies you're using. So for me, I always say you need to speak with somebody who will help you to come up with an assessment of what you need, the measures that you can take, because there are measures that you can take even without any costs. For example, when you talk about security of data, and you have maybe cabinets that are open which contain personal data of clients, and then they're not even lockable. You start with that. Start with things that ensuring that you store very critical data, in lockable, fireproof places. Ensure that you have secured the personal data from flooding. Ensure that you've talked about train employees on phishing. That those aspects that you can actually handle if you know what you're supposed to be doing without any cost, but there are those aspects that will require a cost. So it depends and it varies for each organization. So the best thing is to see somebody who can help you to assess this and come up with what is required according to your budget, how you can implement that.
All right, thank you. I think the rest of the questions some we have handled during the presentations. And now I would ask members if there's any question, they can ask away. And Faith, if I could ask, when you talk about membership with the, okay, Martin, you can.
Hi everyone, my name is Martin. I hope you can hear me.
Yes, you are clear.
All right, my question is based on how can travel agents comply with data protection, especially on the issue of emailing when you're using, when you're copying maybe email to multiple recipients. How can us as travel agents try and mitigate that risk of using CC for multiple recipients on emails?
Hello, I can try and answer. Hello?
Hello, yes, okay.
Yeah, so a travel agency emailing multiple clients at once. So there's a situation of, let's say, I'm guessing, you can accidentally expose someone's address, and let's say, depending on what information you're sending in the email, you could end up maybe giving someone's personal information, maybe their financial information. So how to comply? It's a bit tricky. I would guess, okay, emailing, I'm guessing, of course, you use a blind carbon copy of an email when sending to multiple clients so that each client's email is hidden from the others. And also, there are various mailing lists or various tools you can use to ensure that messages are sent individually and that each person gets only the information that, without sharing information. I accidentally lost my connection. I don't know if that answered all your questions.
Okay. In terms of membership of DPGSK, what does that entail if any of our member would like to join?
Thank you. So we have a form that is available on our website where you can be able to fill in the membership form. For professional members, which means any person other than a student, there is a fee of annual fee of 4,000, which helps us with implementing most of our activities. For a person who is a student, it is 2,000, and for corporate bodies, we are working on implementing that. Again, we are only about 2 years old. But very soon we shall also be implementing corporate membership. But currently we just have individual, professional, and student, and the cost basically is 4,000.
Okay, thank you. So thank you, Tim, for the good presentations, and I'll be sharing those with the members after this meeting. And for our members, it's good that we continue to seek compliance in all aspects, and data is one of the important aspect of our business. So it's good that we comply. I will share the data privacy's team contact with the members as I send them the presentation. So in case they would like to join membership, they'd like to consult anything, then they'd be able to do that. Then as we go on, we'll have a series of these webinars and we'll cover much more. So thank you, members, for joining, and we can now leave. Thank you.
Thank you very much. It was an honor.